You may proceed.
Thank you, Your Honor. Mr. Dickerman, Larry Feldman is known as one of the...
Can you turn your microphone on?
Sorry. Let me start again. Mr. Dickerman, Larry Feldman is known as one of the top plaintiffs' civil litigators in America, correct?
I don't know about America, but I would say certainly California.
And typically, a plaintiff's civil litigator will file a lawsuit on behalf of a plaintiff, correct?
Yes.
And try to seek monetary damages in that lawsuit, right?
Yes. But I should say, while he's known as a plaintiff's lawyer, I know him also to have defended major lawsuits, and he's now with a major New York firm, so he is certainly doing a lot of defense work.
He started doing a lot of defense work in recent years, did he not?
I don't know.
But he became very well known in Los Angeles for winning huge financial damage awards in civil cases, correct?
I would say that's probably true.
A lot of them were types of personal injury cases, correct?
I don't really know, beyond the 93 case, and I've been reading his name, and I think he was the president. I don't know if it was California State Bar or the LA County Bar. I don't know the specific cases. I know of one railroad case that was a big deal, but, if my memory were refreshed, I would know some of these other cases. But offhand I don't.
Typically in a plaintiff's civil case, the lawyer gets a percentage of whatever the lawyer recovers for the client, correct?
Only if it's a contingency case. If that's the arrangement, for a percentage. That's typical in auto accident cases. It's typical in other accident cases usually. I can't say what's typical in a molestation case, or any other particular case. It just depends on whether the plaintiff has the money to pay the fees or prefers to go on a contingency. Very often I have turned people away from contingency fees, because I tell them, you got a strong case and you're going to be very unhappy if you pay me a percentage after I don't do $100,000 worth of work. You're better off, if you got the money, to pay me hourly to do that. And so it varies from case to case.
If the client doesn't have a lot of money to pay the lawyer in a plaintiff's civil case, typically what the lawyer does is pay the costs, litigate the case, and if money comes in, either through a settlement or a judgment in a trial, the lawyer gets a percentage of that recovery, right?
That's right.
And even though you're aware of Mr. Feldman doing defense work, you're also aware of him pursuing large multi-million-dollar damage claims on behalf of civil plaintiffs, correct?
Yes.
And you're aware of him doing that on behalf of plaintiffs who can't afford to pay legal fees, correct?
I don't know. I don't know who pays him what or how it's done.
Now, you produced some handwritten notes, which you were subpoenaed to produce in this case, true?
Yes.
Some of the notes you produced mention the J.C. Penney case, right?
I know at least one of the pages says that, yes.
Were you involved in the J.C. Penney litigation on behalf of the Arvizos?
Not at all.
Okay. Do you know why you refer to the J.C. Penney case in your notes?
Do you want to refer to some specific notes?
I have a page I can show you.
I've got my originals here of a conversation that I had with Mr. Sneddon on January 9th. Is that the one you're referring to?
I think it's more like January 8th. It says, Liebler, in the corner.
Well, at the top of that previous page it says 1 to 8, but near the middle it says 1 to 9. So I'm assuming that's a conversation I had on the 9th.
To your knowledge, had the J.C. Penney case concluded by the time you were hired?
I know nothing about the J.C. Penney case. I know it arose, there was some conversation about it, and I have no involvement in it. It seems to me that it resolved some time ago. I don't know. 1, 2 years or more. I don't know.
Was it your understanding that that was a plaintiff's contingency fee case where the lawyer gets a percentage of the recovery?
I have no idea what their fee arrangement was.
Okay. When was the last letter you sent Mark Garrigus regarding the Arvizos?
Well, if Exhibit 625 has all my letters to Garrigus, that would be May 29, 2003.
And you continue to communicate with Michael Jackson's lawyer named David LeGrand, correct?
Yes.
And your letters to David LeGrand went through July of 2003, correct?
I don't have the date memorized. But if you've got a letter that says that, then that would be the case.
I have a letter July 9th. Do you want to see that?
I have a letter of July 9th from him. I don't know if I wrote to him after that or not.
Okay. You're continuing to write letters on behalf of the Arvizos through July of 2003, right?
Yes.
And to make a long story short, none of your letters ever discussed the subjects I identified before: molestation, false imprisonment, kidnapping, harm to children, that kind of thing, correct?
They never did. That wasn't the purpose of any of the communications. All these communications were for the purpose of getting things done, not for making allegations about something that would be handled in some other form.
Well, you mentioned harassment in some of your early letters, correct?
Right.
But you never mentioned anything about alcohol in any of them, correct?
Well, first of all, the Arvizos were gone from Neverland by March 26, is my understanding. And the letters regarding humiliation, intimidation, surveillance on March 26 and thereafter was about continuing behavior after they left Neverland.
Okay.
I was writing, seeking for him to get Jackson and his people to stop doing what they were doing. To do affirmative things, stop, return things, provide lists. Not to make allegations of things that Garrigus would have nothing to do with in any event.
Was it your understanding at some point that furniture and material was returned to the Arvizos by Brad Miller?
I don't have any personal knowledge of any return of those things.
Did you ever see a receipt from a storage locker?
I don't recall seeing one.
Was it your understanding that while you were representing the Arvizos, Mr. Garrigus paid rent for the Arvizos in East Los Angeles?
I have no such understanding.
Did you ever hear anything about that?
About Garrigus paying rent?
Yes.
No.
Did you ever hear about anybody associated with Mr. Jackson paying the Arvizo rent in East Los Angeles?
I don't recall hearing of any such.
Did you ever communicate about that to anybody?
To the extent that I communicated about anything with my clients, that would be protected by attorney-client privilege. But I don't recall communicating about that with anybody else.
Have you referred any clients to Mr. Feldman since you referred the Arvizos?
No.
When did you last talk to Mr. Feldman about this case?
Yesterday.
Did you talk about what you were going to say in court?
No. I think all we talked about was whether Miss Arvizo had waived the attorney-client privilege.
And that discussion was yesterday?
And I think we said something about the fee arrangement. Specifically, I can't recall. I was sitting upstairs, and I was returning calls from the office.
Now, as a civil litigator, you're aware that if you obtain a criminal conviction in a case of alleged child molestation, any parallel civil case is automatically won on liability, right?
Actually, I've heard that recently. But not having ever been involved in such a case, I can't say that I know that for sure. I haven't researched the law on it.
But you certainly know that if someone has a judgment of a criminal conviction against them for sexual assault, you can use that in a civil court to establish liability and not have to incur the expenses and the time involved in a trial on liability, right?
I would assume that to be the case.
The only issue at that point would be how much money you get in a civil courtroom, correct?
I don't know if there are other issues, but I think as the judgment, that's true of any criminal action, that you don't then have to go, once again, and prove exactly what was proved with a higher burden of proof.
No further questions, Your Honor.
Mr. Dickerman, before we took the break, Mr. Mesereau had asked you about a letter that you had sent to Michael Kahan, or Kahana, and we took the break and we came back and he didn't follow up on that document. Have you had a chance to see that document dated April 3, 2003?
I did. I found it in my file.
Mr. Dickerman asked you if, in fact, you made a demand for royalties for photographs published in the Globe. Is that correct?
Do you mean Mr. Mesereau?
I'm sorry, Mr. Mesereau asked that of you.
I don't recall if he asked that or not.
Did you, in fact, make a demand for royalties in this letter?
No, I never made a demand for money on behalf of the Arvizos in any letter, in any communication, for any purpose under the sun.
What did you ask the Globe newspaper to do in this case? I'm assuming the Globe is a newspaper.
Yeah, it's a tabloid.
What did you ask them to do in this letter?
I'll quote the last paragraph. Unless the Globe and American media can provide valid consents, as described above, that's referring to consent by my clients to be in the Globe, the Arvizos demand that the Globe and American media immediately cease and desist from using or in any other way exploiting photographs of any of my clients. My clients further demand the Globe and American media cease and desist from any further mention of them in any publications. Close quote.
You asked that they take them out of the newspaper and not put them back in again, is that right?
That was it. The concern was to stop exploiting them, period.
Did not ask for money?
No.
No further questions.
No further questions, Your Honor.
Thank you. You may step down. Call your next witness.
The witness is on his way down, Your Honor.
He is on his way.
He's on his way.
Who is the next witness?
Jeff Klapakis.
You know, I was thinking that between the comedians and the lawyers, I kind of like the comedians better. Laughter. You don't have to respond. Laughter.
Your Honor, while we're waiting, there are a couple of exhibits that have not yet been admitted that I'll ask to be admitted at this time.
All right.
The first one is the notebook. Madam Clerk has it. It's exhibit number 769. That was the one notebook that counsel had an objection to, but we researched it, and I believe found sufficient foundation was laid for that.
Number 769?
Yes. And I can show Madam Clerk the exhibit.
I'm sorry. Are you objecting to this exhibit or just remaining?
I'll submit it.
All right. It's admitted. Come forward, please. You're already under oath. You may be seated.
Lieutenant, you previously testified in this case?
Yes, I have.
And you understand you're still under oath?
Yes.
All right. And just as a refresher, since it's been a couple of weeks probably since you were back, would you tell the ladies and gentlemen of the jury, you are employed by the Sheriff's Department in what capacity?
I am the lieutenant currently in charge of the North County Investigations Division.
And with regard to this particular case against the defendant in this case, Michael Jackson, what is your particular assignment or role?
I am in charge of the overseeing of the entire investigation.
And so Sergeant Roble, then, would work underneath you, correct?
That's correct.
And under your direction?
Yes.
Now, with regard to, we're going to talk a little bit about forensics, okay?
Okay.
And of the decisions that were made in this case with regard to the processing of certain exhibits.
All right.
Now, generally what's the relationship between how items are sent for processing for forensic purposes in the office? Who makes that decision?
Well, generally the investigator who seizes an item, say pursuant to a search warrant, will, once packaging and booking it, will fill out a form for the forensic unit to do a latent comparison, or whatever type of forensic science they want on the evidence.
In this particular case, who made those decisions?
I did.
Now, with regard to forensic examinations, are some items done, forensically examined within the Sheriff's Department?
Yes.
And are some done and sent to outside agencies?
Yes.
Can you give the jury just a general idea of what kind would be sent out and what kind would be done inside?
Well, certainly an examination of items for latent fingerprints, we have that expertise within the Sheriff's Department. An examination of an item of evidence for biological fluids we would send out to the Department of Justice, who has that experience, where we don't.
Now, with regard to this particular case, the Michael Jackson case, People v. Michael Jackson, you were present when the search warrant was executed on November 18, 2003, correct?
Yes, I was.
And in conjunction with that search warrant, a number of items were taken and brought back to the Sheriff's Department, correct?
Yes.
And shortly after that, some plan was put in effect to basically document or inventory what it was that was taken. Is that correct?
Yes.
And who did you assign that particular task to?
Well, when we seized those items, that was part of I'm not quite sure I understand exactly what point in time you're talking about.
Right after you got back from the search warrant. Okay. There were certain items that were placed into bags and certain containers that had items that hadn't been looked at yet, correct?
Correct.
And did you assign somebody the responsibility of going through those items and seeing what there was inside and documenting that through reports?
Yes.
And who did you assign that responsibility to?
Detective Bonner.
And that particular process, let's say from the day of the search till, how long did that take?
Well, it's always been an ongoing process. There's lots of items of evidence.
Well, let me go back. Only as to the stuff taken from Neverland Valley Ranch, not as to any subsequent search warrants.
I would say it's taken Detective Bonner probably a couple of months to go over all that material and examine it.
Now, were you involved in developing what might be called a forensic game plan for the processing of the items that were taken from the Neverland Valley Ranch on November 18?
Yes, I was part of that.
And what was your role in that plan?
As well as providing input and asking questions, I was the ultimate person to make the last decision on what we were going to do.
And with regard to the particular plan, what did you do in your capacity as the person in charge of making these decisions to help you make those kinds of decisions? Did you do any research? Did you do any checking? Did you have people do things so they could give you advice as to what the decision should be?
Yes, I conferred with my forensic unit. We talked about the type of materials that we had, and that we had seized from the ranch. One of the things we decided to do was to go out and get a similar type of material, adult material magazine, and practice with it. Again, we're talking about different forms of paper. We wanted to make sure that any processes that we did to develop and stabilize latent prints would not be destroyed by a previous process. So, that was one of the things that we went out and did, and practiced with that.
When did you commence that portion of your planning stages on the game plan?
Well, the first part of the game plan was to photograph some of the materials. And we started on that process. At that point in time, I stopped the forensic unit, and I asked them to go over the materials with an alternate light source in hopes of developing or finding any biological fluids.
And when specifically do you recall, in terms of from November 18, 2003, was it that the alternative light source was used to process the materials that still remained in the Sheriff's Department custody?
I'd say December or January. December 03 to January 04.
And were you aware of the fact, in your capacity as the lead person in making these forensic decisions, that certain items were taken to the Department of Justice in the month of February?
Yes, they were.
Was that under your direction that they be taken there?
Yes.
Now, let's go back just a second to the testing protocol. You told the ladies and gentlemen of the jury one of the things that you directed staff to do was to buy various magazines and to experiment with them. Is that correct?
Yes.
Now, was that particular experimentation or process development directly related to a particular type of forensic examination, or to more than one type that you anticipated?
Multiple types.
And what would be the multiple types that you had in mind?
Certainly supergluing, and using other types of, I'm not a forensic scientist, but supergluing those would be one of them. Using a process called ninhydrin would be another one. Certainly fingerprint powder, to see if that developed any. We wanted to do. Also examine it with the naked eye as, without any powders or anything on it by using what we refer to as a scenescope.
So most of the things that you just talked about were the processes directly related to the latent print examination, correct?
Yes.
Now, in connection with developing the process that was eventually used to process latent prints or process the magazines that may or may not have developed latent prints, did you consult with any outside agencies in the development of that protocol?
Yes.
Who did you consult with?
The FBI.
Now, the jury's heard a lot about several organizations, and I want to just digress for just a moment and talk about this a little bit. The FBI is a federal agency, correct?
Correct.
Or as Mr. Mesereau would call them, they're the government?
Yes.
Now, where are there labs that deal with the fingerprint and latent examinations?
Quantico, Virginia.
Now, we've also heard another branch of government called the Department of Justice, correct?
Correct.
And when you use the Department of Justice, what are you talking about?
That's a state lab, California's state lab.
And with regard to that particular lab, do they have local facilities?
Yes. Small, but yes.
Do they provide a full range of forensic assistance at the local lab?
No.
Are there certain things that are sent to the local lab, but then have to be sent up to the Department of Justice elsewhere?
Yes.
And to your knowledge, does the Department of Justice do latent fingerprint examinations?
I don't believe they do those. At least we have never used them for that.
Do they do DNA work?
Yes, they do the preliminaries. And then I believe that they send those out to Richmond, I believe.
In a lab in Richmond?
Yes.
Now, after you've told the ladies and gentlemen of the jury that certain materials were sent to the Department of Justice locally for a forensic examination in February?
That's right.
Those materials, particularly those materials that were contained within the Exhibit 470, which is the briefcase.
Okay.
That you refer to as 317. You have the briefcase in mind?
Yes, I do.
And the materials in it that I'm talking about in mind?
Right.
Okay. Now, those particular materials, what happened to them between the time that some of those materials were removed in February? What remained in the briefcase, and the other materials? Where were they, to your knowledge?
Well, a lot of the materials were kept at DOJ, and I believe they were locked up in a safe.
Those are the items removed from 317?
That's correct.
Or 470 in our case here?
Yes.
And the ones that remained in your custody and control, what happened to those?
I believe that those were entered into evidence in the grand jury.
And to your knowledge, were those retained by the grand jury?
Yes.
Now, at some point, you received the items back from the Department of Justice, the local Department of Justice, that had been sent in February. Do you recall that?
Yes.
Do you recall when you got them back?
The latter part of July, almost August.
And when you got those materials back, most of those were magazines, is that right?
Yes.
And was a decision made at some point after that as to how, and in what priority, certain materials would be processed?
Yes, based on the testing protocol that we had done, plus our conferring with the FBI, we developed our own protocol to what would work best in trying to develop and stabilize any latent prints on the magazines. And then that, I believe, was in August, 2004. In conference with your office, my office, we developed prioritizations of which magazines to do first.
Do you have an estimate of how many magazines were involved here?
100 plus.
Have you ever had a situation to do latent examination on 100 magazines in a case?
Not every page.
Now, you said that there was a meeting between your department and the district attorney's office.
Right.
With regard to prioritization, what decisions were made with regard to how? What month was that?
August, 2004.
And with regard to that, what prioritization was developed for the processing of the magazines in this case that were seized from Neverland Ranch on November 18?
Prior to, the priority was placed on item 317, the magazines from the briefcase.
And thereafter, what was the priority to be?
I believe, and any other magazines found within Mr. Jackson's bedroom. Bedroom, den, room.
Upstairs or downstairs?
Yes, bathroom as well.
Now, did you or anybody under your direction take steps to obtain the release of the magazines and the briefcase that we refer to in this case as 470, and you refer to as 317 from the grand jury?
Yes.
And what occurred in that connection?
Detective Bonner, we had to get a court order to get it out of the grand jury. In order to do that process, I believe the court requested that we replace what we took out with photographs. Detective Bonner, and I believe the defense had to review that as well, before we can get the court order. I sent Detective Bonner to the court, who took photographs of the items from the grand jury. And then in October we received a court order and got the magazines out.
Now, you've indicated to the jury that certain materials were returned to your possession and control from the Department of Justice in around July of 2004.
Yes.
And you've indicated to the jury that you got the other materials from 470 from the grand jury in October of 2004?
Right.
Had some processing of latent prints begun before you actually got the remaining materials from the grand jury?
No, we were doing other phases of the forensics. Photographing, splitting the pages, putting them into separate binders. We were doing a lot of pre-processing before we went into the magazine.
Okay, so it was part of the protocol process for examination, but it wasn't the actual examination process. It was the prep process?
Yes.
But you had begun that process before you got the materials back from the grand jury?
I believe we had started that process in January, with some items that neither went to DOJ or neither went to the grand jury. So
it was just an ongoing situation?
Yes.
Now, just to give the ladies and gentlemen of the jury some idea, you're a head. Your title is what?
Lieutenant.
And you're in charge of what?
Criminal Investigations Division.
Now, during the time from, let's say, January of 2004 till the time of October of 2004, were there other major events that required you to take personnel off this case to become involved in major investigations?
Especially my forensics personnel, yes.
And what was that?
In July, we had a homicide. In September, and this is, September, 04, we had an officer-involved shooting that resulted in a justifiable homicide. And in October, 04, we had another homicide.
Now, with regard to the process of beginning the examination of the magazines that you've already described, the prep, and you've already indicated when the actual latent comparison process began, did you learn at some point that there was a deadline set for the completion of the project?
Yes.
And do you recall when it was you learned that there was a deadline set?
Yes.
When was that?
When we discussed the magazines, I believe in October, 04. But that wasn't the date. I was given December 12, I believe.
So you basically had 10 weeks to complete the process?
Yes.
When you found that out, did you have to bring extra personnel in to help process all these?
Yes, I did.
Now, the FBI has a lab in Quantico that you've said does do latent print examinations, correct?
It's quite a big lab, yeah.
And was any discussion had with regard to sending some or all of these materials to FBI?
We talked about it.
And was there a reason why it wasn't done?
Yes. I felt that we had already begun some processes with some of the materials. And by piecemealing out things to do, I would lose control over the evidence. And I wanted to have accountability over this evidence. So I had the utmost confidence in my staff, given the time constraints, and to handle the job. And so I chose to keep it in-house.
In your experience over the years that you've dealt with the FBI and fingerprints, does it take them a while? Did they have to prioritize your request with other requests from other agencies?
Yes, they did.
And you indicated that you didn't think that the Department of Justice, the State Department of Justice, did latent examinations at this point in time?
I'm sure they will do them for smaller agencies. But again, it's a prioritization process, and we're a mid-level agency, and we're fully capable of doing that kind of work.
Thank you. I have no further questions.
Good afternoon.
Good afternoon.
Approximately 69 personnel did a search on Neverland Ranch, correct?
Approximately 69 persons were involved in the operation, yes.
And how many were sheriffs, if you know?
I would say 90%.
Have you ever done a search with that many sheriffs before?
I was involved in a peripheral investigation with the city of Guadalupe where we basically took over the town, so, yes, I'd have to say.
Your typical homicide investigation in Santa Barbara County, you don't use 69 sheriffs for a search, do you, of a home?
No.
And your typical homicide investigation in Santa Barbara County, you don't even come close to using that number in a search of a home, right?
That's correct.
It was done here because Mr. Jackson is a celebrity, correct?
That's not why it was done.
The fact that Mr. Jackson is known as a megastar around the world has nothing to do with taking 69 people to search his home?
There were a lot of other operations going on in regards to the search that required additional personnel.
Were you in charge of the search?
Yes, sir, I was.
And isn't it true that your office contacted the media before the search?
That is not correct.
Do you remember an operations plan you put together to have people read before the search?
Yes.
Did it talk about media observing the search?
One of the personnel that we had there was a public information officer. That the sole purpose of having him there was, once we conducted the search, we thought the word might get out.
Before you conducted the search, did you make plans for any type of press conference?
I believe the sheriff's department was involved in that process, yes. I didn't. Your question was did I?
Let me rephrase it.
Okay.
Before approximately 69 people searched Mr. Jackson's home and surrounding location. Plans were already in effect by the Santa Barbara Sheriff's Department to conduct a press conference, right?
I believe that they planned that.
Did that have anything to do with the fact that Mr. Jackson is a megastar?
I believe that we do that for all newsworthy stories that we become involved in.
You haven't answered my question. Let me rephrase it.
The answer is no, then.
So the planning of a press conference by the Sheriff's Department before the search of Mr. Jackson's home and the plan specifically directed at a press conference had nothing to do with the fact that Mr. Jackson is perceived as a megastar, correct?
Maybe it was. I'm not sure I can answer that. I mean, it was involved with who it was in the case, the type of case that we were investigating. It's a newsworthy item.
Did the fact that Mr. Jackson is perceived as a well-known celebrity internationally have anything to do with the number of people involved in the search?
Objection is asked and answered, Your Honor.
Sustained. Sustained.
Who planned the press conference prior to the search?
Well, I'd have to say Sergeant Chris Pappas was involved in that, but I'm not sure. I was involved in a different aspect of it. I think that they were talking about the potential of the media getting involved in this, and so they wanted to have a plan in place.
How fast after the search began was there any press conference?
Mr. Mesereau, I couldn't tell you that. I was so engrossed in the events on the ranch that I wasn't paying attention to what was going on outside.
Do you recall your participating in any press conference related to the search of Mr. Jackson's home?
No, I don't believe I was.
Was anyone from your office involved in that press conference, to your knowledge?
There was a press conference with, I believe, the public information officer outside of our office.
Before you conducted your search, press releases had already been printed regarding the search, true?
Your Honor, I'm going to object. No foundation.
Foundation is sustained.
Do you know whether or not, before you conducted the search of Mr. Jackson's home with approximately 69 personnel, any press releases had already been prepared regarding the search?
No, I do not know that.
Did you ever see such a press release at any time that you've been involved in this case?
It's possible I have. I can't tell you when. Certainly, I don't believe I saw one prior to the service of the search warrant.
Were the people who searched Mr. Jackson's residence instructed in advance how to handle the media?
Your Honor, I'm going to object to this as immaterial, irrelevant, and beyond the scope of the direct examination.
Did you go into the search on direct?
I just asked him if he was there. I didn't go into any of the details of it. Just to lay the foundation for what he did to process the stuff forensically.
He did go into the search, Your Honor. Not the media issue, but he did go into the search.
All right, I'll allow the question. Do you want it reread?
Please. Record read. Yes.
Who did the instructing, if you know?
Probably myself, Sergeant Koopmans, possibly Sergeant Roble.
Did you say probably yourself?
Probably We had an operations briefing where several persons involved in different aspects of the operation gave briefings on their aspect.
Did you engage in any such briefing?
Yes, I did.
When was that?
The morning of the search.
When you arrived at Neverland to commence the search, did you see any representatives of the media present?
I saw a car on the side of the road. There wasn't an insignia on it.
Did you see any helicopters flying above?
No.
At some point, did you see them?
At some point, there were several helicopters there.
Do you have any idea who notified them about the search?
I have no idea.
No clue at all, right?
I have none.
Do you have any knowledge that anyone in the Sheriff's Department notified the media about the search of Mr. Jackson's home?
I have no knowledge of that.
Okay. Regarding forensic work at Mr. Jackson's home, did you put into place any safeguards to avoid contamination of evidence?
All of our personnel are trained, so that is a safeguard in and of itself. We proceeded as cautiously as we could through this large estate. We put people in charge who had more experience than the others who directed them. And from that standpoint, I believe our investigators who were doing the actual searching were wearing gloves.
Is there any other safeguard that you recall putting into place before the search regarding possible contamination?
None, it escapes me at this point.
Do you know what people were wearing on their shoes before they walked through his home?
I don't believe they were wearing anything other than the shoes.
What kind of shoes were they wearing?
I couldn't tell you.
Were you in Mr. Jackson's home during the day of the search?
Yes, I was.
How many people were in Mr. Jackson's home on the day of the search that were part of your operation?
Inside his main house?
Yes.
I would say inside his main house, it changed, anywhere from 15 to 25 at any one particular time.
How many people in total out of the 69 that were involved in the search of Mr. Jackson's residence entered his house that day, if you know?
Again, the main house?
Yes, please.
Well, we kept a log of people that were entering in the house. I myself entered and exited several times, so I cannot give you an adequate answer to that question.
It was more than 25, was it not?
That were conducting the search in the main house?
That went into his house at any time during the day.
I'd have to say yes.
Was it more than 45, to your knowledge?
I'd say that possibly could be correct. We were conducting interviews in the house, so, yes. And you're talking just our personnel or perhaps ranch employees as well?
No, your personnel.
Then I'd say you're probably somewhere around that.
Close to 45?
I'm assuming, yes.
You have never been in an investigation where 45 people were allowed to walk into someone's home, correct?
In a home, no.
This was the first time, correct?
It's the first time I've been involved in something, or an estate this size, that we had that many people.
Did the fact that Mr. Jackson is a well-known celebrity have anything to do with the number of people you allowed into his home on that day?
No.
In your typical homicide investigation, 45 people don't enter a residence, correct?
No, they do not.
What were the hours you conducted that search during the first day?
I believe 8 or 9 o'clock in the morning till 11:30 at night.
You then conducted a second search of Mr. Jackson's home, correct?
In, I believe, November, 04.
And what were the hours that you kept in that search?
I believe we entered about 9 o'clock in the morning and left in the afternoon time.
That search was actually in December, wasn't it? December 4th sound right?
It could. It's possible, yes.
Now, both of those searches were done by surprise, correct?
Yes.
Special efforts were taken to make sure that Mr. Jackson or his family did not know the search was going to be conducted, right?
We didn't publicize it.
But special efforts were taken to make sure Mr. Jackson and his family didn't know about either of these searches in advance, correct?
No more special than we do in any other search warrant. So I didn't do anything different.
Let me ask the question again.
Okay.
I don't think I've gotten an answer, but...
Your Honor, I'm going to object to counsel's comments, and it's argumentative.
Sustained.
Were you in charge of the second search on or about December 4, 2004?
Yes.
Would you agree that within minutes of the search of Mr. Jackson's residence on December 4, 2004, the press knew about it?
I wouldn't say minutes. I'd say that the press eventually found out.
They seem to know very quickly, correct?
Within an hour.
Do you have any idea who notified them?
I have suspicions.
Do you think somebody in the sheriff's department notified them?
No.
Was a press release prepared regarding that search?
I don't believe so, but I'm not sure on that.
Have you ever seen a press release regarding that search?
I have not personally seen it, no.
So are you telling the jury that there were efforts made in advance to deal with the media before the first search but not before the second search?
What I'm telling you is that my job was not involved in that aspect of it. That was turned over to our public information officer. My responsibility was the service of the search at Neverland, and that's where my operation stayed.
As the one in charge of both search teams, did you have any involvement with your public information office?
Just notifying them that we would be conducting a search on that day, and at Neverland Valley Ranch.
Were you ever asked to review in advance any information designed to be published by your public information office about either search?
I do not recall reading a press release, as you call it, prior to the service of any search warrant at Neverland.
What safeguards were taken to preserve evidence that you seized from Neverland on November 18, 2003?
Object is asked and answered.
I asked about contamination, Your Honor. I think my question is broader. But I could rephrase if the court wants.
All right, rephrase.
With the exception of issues of contamination, what safeguards were taken to preserve evidence seized at Neverland on November 18, 2003?
Well, initially, we videotaped our entry into the residence. We also videotaped and used still photography. We also did that at the conclusion of our search. The people that entered into the residence were logged in and logged out. Those people entering the residence that were going to conduct searches were wearing gloves on their hands.
Anything else you can think of?
No.
Were there any safeguards you put into place to try and preserve any DNA evidence that might exist?
The only, other than collecting the materials, the adult material, the magazines and the bedding from Mr. Jackson's bedroom, my only involvement was directing my forensic unit, was assisting to get the search warrant for that material and directing them what we were to take. They handled the operation themselves.
Did you say you were in charge of obtaining evidence from Mr. Jackson's bedroom for possible DNA testing?
I was aware that there was bedding material and a bed in his bedroom that was not part of the original search warrant.
Was that material obtained for DNA testing?
I believe that it was.
When, if you know?
I do not know the exact date. It was submitted to the DOJ lab, I believe.
Was it obtained in the search on November 18, to your knowledge?
The bedding?
Yes.
Yes. There was other materials too, I believe, that were submitted.
And when was this material submitted to DNA testing?
Again, I can't give you the exact date. Sometime early part of 2004.
You never even asked for Mr. Jackson's DNA until December 4, 2004, correct?
That's correct.
That was over 1 year after the initial search, correct?
Yes.
To your knowledge, did the FBI do any DNA testing in this case?
To my knowledge, no.
Did you direct the FBI to do any particular kinds of forensic analysis in the case?
Yes, I did.
And what were those types of forensic analysis?
They assisted us with some of the computers that we had found, particularly the Macs.
Anything else you asked them to do?
I believe I asked them to do some background information on some of the other people involved in this investigation.
How much time did the State Department of Justice spend on forensics testing in this case, if you know?
I do not know that.
You made some statements that the FBI assisted you, right?
Yes.
What does assistance mean?
Well, they provided me some information, again, on backgrounds of persons that became involved in this case. They sent out, I believe that they call it a CART unit. That is their forensic computer examination team that assisted us in forensically examining these Mac computers that we were not able to do ourselves.
Counsel, I'd like to stop a couple minutes early, because I've been asked to. The attorneys need to talk to me, right?
Yes, Your Honor.
All right, we're going to stop. To the jury, tomorrow, don't come here. Laughter. To the jury, I'll see you Friday morning, 8:30. All right, counsel, I was just giving Mr. Oxman some medical advice.
I thought you were giving him his $1,000 back.
Your Honor, do we go in your chambers? You want to go to chambers?
The matter I'm talking about doesn't need to go into chambers.
Did you want to go into chambers?
If it's the issue we talked about, I'd like to go in chambers.
Okay, this should be done in open court. Your Honor, I wanted to tell the court, because I made some representations to the court a few days ago, and I notified counsel last night. We have had to juggle the way we're going to put on evidence in this case. And I want the court to know that we intend to start putting on the 1108 evidence on Monday. Instead of 2 weeks, like I said originally. And these sort of things are beyond our control. In any case, that's what we're going to do. I wanted the court to know that, because you asked us about the instructions and stuff.
The instructions.
And I wanted to tell the court that we reviewed that and we already submitted our instructions in that regard, and specifically the Calgics, and that's what we.
Tell me what ones, you have submitted.
I will single them out. I just talked.
Friday you could give me the ones you're singling out?
I will, Your Honor.
And counsel, you could give me something Friday?
Yes, Your Honor.
All right.
That's what I wanted to do. I wanted to make the court aware of that. Thank you very much.
And you wanted to, is that it?
Yeah, I guess so. Mr. Mesereau?
All right, court's in recess.